Do you want to start a thriving real estate career but don't know where and how to start? Do you want to become a successful realtor or investor but lack the required knowledge and skills? Gear yourself up with the best and actionable advice here on the Real Estate Rundown. Tune in as Shannon Robnett talks with industry veterans about all kinds of asset classes, market trends, challenges, management techniques, and success stories. Listen to informative discussions with valuable tips that will serve as the foundation for your incredible real estate venture. Now, here's your host, Shannon Robnett.
Welcome back to season 2 of the Real Estate Rundown Show. I want to thank you guys for staying with us and putting up with us all year long. It's been an incredible journey. We've had some amazing guests, and today's really no different. Today, I have got the honor and the pleasure of talking with a gentleman that I've gotten to know over the last year, a guy by the name of Kevin Day. And Kevin has got a unique story. He's got an incredible skill set that is very, very sophisticated, but it's one that you're going to want to stick around and listen to because Kevin talks about asset protection. And I know everybody's got an LLC, everybody's got a corporation, but that doesn't really protect you to the degree that you need to be. And Kevin and I are going to dive into that, and we're going to get to the nuts and bolts of how you really, really set yourself up like the 1% does to protect yourself long-term and keep your stuff your stuff. So with that, I'd like to welcome my guest, Kevin Day. Kevin, how are you, man?
Very good, Shannon. It's great to be here.
So Kevin, you come with a long list of accomplishments and skill sets. Why don't you give us a quick rundown of how you got to be doing what you're doing and kind of the short version of what got you there and why you decided to specialize in this area?
Yeah, it was a circuitous route. I was an international lawyer already. I speak Chinese and did contracts. And the U.S. signed the Hague Convention on Trusts in 1987, and it was a game changer for entrepreneurs. It was the first time that you could create an irrevocable trust, and we'll get in those details later, and name yourself as a beneficiary rather than giving it away to whoever your heirs were and not having any access to your assets. And I started writing books, got about 5 books published back in the early 90s. There was only one guy that beat me to a no-low press book, Arnold Goldstein out of Florida. And I'd love to say that I was particularly brilliant. It was just good timing, good luck.
Well, Kevin, one of the things that I find with humble people like yourself that it's not just the timing, it's the persistence. Anybody can have the basic general knowledge. It's the persistence to become an expert, and it's the timing with which you bring that expertise to the table. But I don't think you give yourself enough credit with that as far as what you do know and the space and time that you brought that expertise to the general populace and people that are looking to protect their assets.
Yeah, well, thank you, Shannon. Essentially, entrepreneurs said, hey, I want one of these. I don't want to own anything. I want to control everything. They went to their lawyers. Their lawyers didn't know anything about it. They went to the continuing ed people, and they found Arnold and me, and we became the national gurus for continuing ed for lawyers and CPAs, and had a fantastic time, very successful, which means that there aren't that many people in my bar. There's only about 8 lawyers that are true experts in the offshore trust. There's more in the domestic versions that came up about 11 years after the Hague Convention. And when you're successful, you don't have to be a mill. You really work
Right.
with the clients. You don't, I have 28 staff at my law firm. We do revocable living trusts, we do wills and all that stuff. If you're just a living trust person, you have to do thousands of them to cover your nut. And with the complex stuff we do, that means that I can spend the same amount of time with some little person that just has, 2 single-family residences and is a W-2 employee. Their estate is just as important with the person that has 160 doors,
Right.
And I really love that I was lucky enough to be able to be in that position. And a few people that are in our area, it's like, oh, if you don't have, a $10 million estate, I'm not talking to you. And no, we have people that are, $200,000 estates, and they don't want to lose it. And they're in a high litigious business,
And that's the essence, right? Is that creating that solution is not a one size fits all. Everybody's business is a little bit different. There's different things that people want. There's different realities, and in your journey, you've seen it all, done it all. But really, what was at the core was that you were still getting to the protection, right? I mean, we all still want that protection, and we all start out with the concept that, oh, we'll put it in an LLC and you'll be protected. And there's truth to that, but the rest of the world is sitting out here trying to eat your lunch. So take us through that process of, yes, there is protection in the LLC, but why do we need more protection than that? Where do we need to go to be able to make sure that we're completely indemnified?
Yeah, and it's not just the regular entrepreneur belief, it's lawyers' belief is that LLCs or corporations are the only answer. Real estate is going to be an LLC. You go to a corporate lawyer, real estate lawyer, or an estate planning lawyer and say, I want lawsuit protection. They say, how many things do you have? Okay, you need 7 LLCs.
Right.
And they're done serving you. And all a company does is protects you from what's inside that box. And as long as the corporate veil, everybody's heard that term, corporate veil can't be pierced. You didn't buy groceries with your, business credit card, and you keep everything up and, do your minutes. It should stay in that box. But there's 2 things, and we have answers for them. The presumption is you'll lose what's in that box if that's the problem. If you have a piece of property, the boiler blows up, a family of 5 die, they're going to take that property that harmed them at least, and they're going to try to say you were negligent in some way that makes piercing the corporate veil. But let's say they can't do that. You're still losing that property. We can remedy that. But what happens if they sue you personally? It has nothing to do with your investments. You look the wrong way when you're going through a light and hit somebody. And then they sue you, and then they ask you, what do you own? Oh, I don't own real property, but I own 3 LLCs. What's in the LLCs? Real property? Great, we're going to take those LLCs.
Right.
There are these charging order things, and we can get into that. But there's so much more to do. And lawyers just don't think the way.
And I've had conversations with you, and we've talked about, the everybody gets to this level where they can do what they need to do. Like you said, they become a mill, and they realize that diving deep takes time. Staying on the surface and being the mill is where the money's at. And I do have a funnel of, I can do 35 LLCs a day. But the reality is, let's break this down a little bit more. So I own an apartment building, and I put that apartment building in an LLC, and I do everything right. And that LLC is what owns that building.
Correct.
And so when there is an incident, when there is an issue, the LLC is designed to create the separation between you and that apartment. But it's not designed to protect the apartment. It's designed to push off the liability away from you personally. But it's really, what I hear you saying is that it was never designed to salvage or to save or to ensure the continued ownership and control of that asset. It's just to create separation.
Exactly. That's all they do. And that's
so What is it that you do? It sounds a little bit like, the World Economic Forum. You will own nothing and you will love it, right? I think your version of it I like a lot better than than their version from just a little bit I've heard. But how is it that you can keep that so that I have an LLC, right? And we still use an LLC, correct?
Right.
And that asset that the boiler blows up and there's insurance, but and they are able to get to the limits of the insurance. But how do you protect that so that all my stuff still stays in my control?
Yeah. Well, let's back up because as we know, and your other podcasts have actually, touched on this, that we have 94% of the world's lawsuits. And but good entrepreneurs, we don't, freeze like a deer in the headlights, and we press on. And that's great because it runs the economy and it builds wealth for our families. But there's only two ultimate owners in our legal system, and companies are not one of them. They are separate legal people. The IRS and the Corporations Code says that your LLC, your corporation, your limited partnership is not you, and you have to treat it with that respect as if Kevin Day owns that LLC. But somebody has to own the LLC. That LLC can be owned by a corp, by a limited partnership, by an LLC, corp. It will only end in two things: a human, nobody owns you, and nobody owns an irrevocable trust. And so you don't want to be the owner. And if we can create a separate legal owner that's all about you, you're the 100% beneficiary, it's all for you. But if you get sued, you can say, it's not me, and the law supports it. You're in a great position. That's what Elon Musk did just 11 months ago. He got into a spat with another billionaire. The billionaire says, I'm going to sue you. And he said, sue away. I don't own anything. And
Right.
so he had peace of mind. The suit actually started. They sued him for $133 million, happened to lose. But
What's that between billionaires? I mean, Kevin, really, when we put that into perspective, 130, that's like you and I arguing over lunch.
Yeah. I'm suing you for $25.
That's it.
But he wasn't sweating it. It didn't destroy his attitude and his business prowess, because he said, I don't own anything.
Yeah.
And you can put people
So
in that.
you've mentioned several times this irrevocable trust, and
Mhm.
we all hear about the trust, and usually people deal with that in their estate planning is the thought process, right? I've got to get a trust. I've got to do an ILET, or I've got to do some sort of a trust where all my assets go in there so that they can be passed on. But you're talking about using that trust as something that works even better while you're still alive. And that
Right.
you can direct and control. So let's break it down. Talk to me about what the difference between a revocable and an irrevocable trust is, so that we can then take that to the next step and understand why that is where you want everything to end.
Right. You want a revocable living trust because we're all in that conveyor belt. We're going to die. And you don't want some lawyer getting 6% of your estate for filing 5 forms in the probate court. So they're important, but if they're revocable means changeable, and you get sued, the court will go, oh, then revert it back to you so you can give it to the marshal that's going to give it to your plaintiff. Irrevocable means that to some degree it's not changeable. An ILET, which is for holding insurance, irrevocable life insurance trusts, those are great for their job. They are making sure the proceeds and face value of an insurance policy is outside of your estate, so it all goes tax-free to your heirs. But you're not a beneficiary of that. Your heirs are.
Right. That's the bad thing about life insurance and those kind of things, right? You're never around to see the positive that could do.
Right. These trusts are unique, and before 1987, you couldn't do it. it wasn't an irrevocable trust. If you name yourself as a beneficiary, it had no lawsuit protection whatsoever. But because we signed that, and subsequent, because the offshore trusts aren't inexpensive, but in 1997, US states started to pass laws that copycatted the Hague Convention. So you can create an irrevocable trust, name yourself as a beneficiary. What we do is create one underlying Wyoming or Nevada privacy company, so your name isn't in public record. You're not the legal owner, and we can prove it, but you can control it. You can have the checkbook. It's your little piggy bank for your family.
So let me try and understand this. You know, you have to remember, Kevin, I am a contractor, so concepts are sometimes hard for me. But we're going to create this entity over here. We're going to create this with a piece of paper. We're going to give it an EIN, which means that it becomes alive according to the IRS, right? And the federal government. And it's going to then get given all of my things. So I've got an office building over here. I've got an apartment building over here. I've got some gold and silver. All those things are going to get given into this entity that we created on paper. And this owns it, but it just sits over here. And since it's not real, I mean, it's real, but it's not real. I mean, it sits over there. It can't get into trouble. It can't cause a lawsuit. It can't be negligent. It can't be dereliction of duty. It can't do any of the things that would get you sued. Is
not exactly. We do put everything in a structure like this if it's pre-marriage divorce planning, because you don't want to be the owner, and it works. Prenups are always challenged, and they're 1 out of 5 are not recognized by the courts. But what our job when we work with a client is, this is an over-exaggeration, but we have 3 categories: zero and low liability assets, cash, portfolio, notes payable, gold, crypto. That's zero liability. That's the low-hanging fruit that a plaintiff's lawyer wants. Those definitely go into this privacy company owned by the lawsuit-proof trust. Then we have super high liability, real property. If you're a syndicator, you've tripled the liability because you're taking people's money, and you've got SEC and other government regulation liabilities. But let's just take your regular investor. Those are high liability. And then there's stuff that's high value, certainly machines that can take people's arms off, a restaurant or a coffee cart. You can't buy enough insurance for one evening that went bad with a cold.
Right, exactly.
Real estate's a perfect example of that middle road. It's high liability, but high value. What do we do with each one of those? And what we do with real estate is we put a friendly lien on it from your piggy bank company.
Let's say, wait a minute, Kevin. I've never heard of a lien being friendly ever.
Yeah, if you go to Kevin Day Lending, you know, and I'm charging good interest, that's one thing. If you go to Bank of America and they're the lien holder, that's one thing. But if your own piggy bank, if we call that privacy company Golden Mountain Funding or Pine Tree Lending, and that holds your cash portfolio, gold, crypto, intellectual property, notes payable, all the zero liability assets, we've taken care of the hard stuff that's zero liability. Then your real property or other businesses that can harm people and get sued, we put a lien from yourself to yourself. And since the law says, one, the company is not you, and we've gone one step further and made sure 100% of the ownership isn't in your personal name, but in the lawsuit-proof trust, and you're the beneficiary of it, that's a friendly lien. Our job is to create the proper consideration so that if somebody sues, A contingency lawyer, they're a business partner on a project. They look at you. Do you, live in the Hollywood Hills and drive a Bentley, or do you live down in some other part of town driving a Yugo and rent a studio? They're not going to take that second course.
Right.
If you own a bunch of property, but Union Bank is on first and Golden Mountain Lending is on second, there's no equity there to sue. They can say, you've got a great case, but I'm not going to spend money and my paralegals and everything working on this.
Right.
Hourly lawyers will still take your money and do the investigation under your dime, and they'll come back and say, let's see if there's any insurance, because yeah, there's 20 Joe's plumbing trucks out there. I see him myself. I figured he was going to be a good hit for us in this lawsuit, but there's UCC ones. There's liens against all of his trucks and his building where his warehouse is. Let's just see if there's some insurance. They're going to get out. If they ran a whole suit and gave their client this piece of paper, litigation attorneys are not collection attorneys. It goes to some other law firm. That law firm is going to say, oh, did Joe Smith Esquire tell you that he doesn't have any equity in all this stuff? Do you want to sue for malpractice? You'll get a lot of money from the lawyer.
Right.
So even hourly lawyers, they'll pound their chest in front of you, but they're telling their client, get out quick.
Yeah. So really what you're doing is then you're taking this entity again, we're back to the entity, right? And we've got the other entity that we're creating that is taking all of the value. And when I say value, I mean, we've got a $10 million asset with a $5 million loan. There's $5 million in value, right? That's the liquidity that's in there. So we're putting the asset in here. So it's got this, and it has, this entity has the $5 million loan from Bank of America and a $5 million loan from Golden Mountain Bank.
Right.
And Golden Mountain happens to be paying the shareholder distribution to me. That's how I'm getting money, because Golden Mountain is charging 6% interest or whatever. And so it's getting paid $300,000 a year for its loan that is then being distributed to me. So I have cash, so I can live. And now these two assets are very protected. But in the case of I look left and somebody came from the right, I have money coming in. How do you protect for that?
Well, there's two things. What we typically create 95% of the time is what's called a dormant trust. You're the beneficiary, but you're not the trustee. But we don't give anything to the trustee other than a piece of paper saying that it owns an underlying company. There's a lot of tactics in between, but the most extreme tactic we can take is make it an active trust. Somebody gets a mammoth judgment against you and you still need to live. As long as you don't receive the funds directly to pay, just like a Carnation grandchild with a $16 million judgment against them, you say, go to the trustee and say, here's my MasterCard bill for this month. I'm out there charging, but I'm not writing a check to pay it off. Here's my, please sell this house and buy me another house.
So what it sounds like to me, Kevin, is this reminds me of the cartoons I used to watch where Wile E. Coyote used to show up and the sheepdog would be there and they would battle it out all day long. And you got the one lawyer trying to protect things and you've got the other lawyer trying to uncover things, right? And you're creating this layer of protection, and you're using the exact same rules that the other attorneys use to come for it to protect it. So,
exactly.
So you're not inventing anything new. You're just putting it together in the right steps and the right sequence, that if I do A and B and C, when the inevitable or the unlikely happens and D, E, and F become our contingency, we have that all there and protected. Otherwise, things function as normal. Money goes into an account. You get money out of an account. You live your life as normal, and you're able to create that ability. All of that tied back to an irrevocable trust, which is not a real human, that has the control of that has the ownership of the asset, while Golden Mountain Funding, for this example, and its board of directors have the checkbook.
Exactly.
I got it right?
Yes, sir.
Wow. So
Podcast done.
It's not complicated, but it's definitely not easy. I can
Yeah.
follow it, but it's got a lot of moving parts in there that keep you. I mean, you mentioned the Wyoming corporation, because that's anonymous. That keeps you from, showing up anywhere. So now things just kind of disappear into the mist. If they do happen to figure out that this is who owns it and they can track it down, there's still not anything to have. And most people that wind up initiating the lawsuits, in 94% of the lawsuits of the world that are started in America, are started by somebody has an unfortunate accident and a lawyer that converge on a corner and say, we're going to make this right with you. And for that, we're going to take a contingent fee, because most people that wind up wronged in a lawsuit don't have hundreds of thousands of dollars to feed that.
No.
To go the distance.
No. And, the stuff that we've seen, we want privacy about it. And in fact, when our clients have had issues, 80% of the time, the adverse party never finds out that there's a trust. They see Golden Mountain funding, but they don't think it's our client. They don't even ask the right questions, bark up that tree. The 20% that have found out about the structure, after people have gotten judgments, have entered into very positive settlements with our clients because they can't get the assets. We want privacy. We don't want them to know it's related to you, but I better not be saying something behind closed doors that I'd be embarrassed to tell a judge. It needs to work. I should be able to tell the judge and the adverse party, this is what we did, this is when we did it, this is what happened, and here's all the law. You're not going to be able to get it.
Right. And that's almost as much of a deterrent as, the little blinking light that says we have an alarm here, right?
Yes.
I mean, you're looking at it going, actually, that's quite complicated, Kevin. I don't know that I want to go through all the effort to unwind this. Like you said, let's go the easy route because it's about a payday here. Let's go the easy route and let's get the insurance and go for the limits of the insurance, which may be $500,000 or $2 million or whatever. Right. Because, you see this, and we just saw this with Alex Jones with InfoWars. He got $100 million judgment, right? I mean, there's no way you're going to collect on that, right? And you see these massive judgments that get thrown out there. And unless you're somebody huge like, Wells Fargo or something, when they got in trouble there for doing the whole credit card thing, until you're somebody like that has billions and billions of dollars, you're not going to be able to collect on that. So what you're really doing is you're putting up a really high fence. You're putting up a really good series of events that will take you to the conclusion that if you try and scale this castle wall, it's going to take you a lot more time than you thought. It's going to take you a lot more effort than you thought. And the princess is kind of an ogre. So, so really most of that is through thoughtful design, a deterrent that then mitigates probably the desire of most attorneys, like you said, to even want to go down that road.
Yeah, the friendly liens from your own lawsuit proof structure is golden. We had amazing successes through 2008 through 2015. We had people that were upside down. They're saying, hey, I'm upside down on these 4 properties, but my home and these 2 other properties are free and clear or have lots of equity. I'm totally hosed. Some of them didn't even get deficiency judgments. They looked at it and said, it's not worth our time. Some of them got deficiency judgments. And we said, have you looked at our client? And they went away. We only had 5 judgments that were perfected in other states that then went to the states where our clients got perfected there, and they still 3 of them settled and like 4 others went away.
So really there's still, when you say went away, they're still outstanding, but it's not something anybody can do anything with because there's they've realized that they went through all that effort and here they are, and they have the piece of paper, they've got the charging order, they've got all the stuff in order, but they realize that they've chased a ghost this whole time.
Yes. The only reason why the 3 settled is they didn't want to have that hanging, out there for 10 years.
Sure. They settled, and the other people realized, look, I guess at this point, if we can cover our fees, we're going to be in great shape, because otherwise we're a total loss, because we realize where we're at. And, so it's really, to me, it's designed to put the control in your hands. It's really designed to do exactly what everybody believes their LLC is going to do, right? Everybody has this belief, and this is the thing that, in our conversations that I've had with you, is it's really designed to make sure that people understand that the LLC isn't all it's cracked up to be. And beyond that, this is really what you think the LLC is doing for you. Now this actually does it, so that you're outside of being idiot proof, and you can't ever idiot proof that, where, you've got to do the things in the right orders. So now you've got this whole thing. How complicated is this mechanism that you set up to operate? I mean, can a contractor do it?
Yes, Shannon, even you.
There's hope for me, Kevin. There's hope for me. I love it. I love it.
So it sounds complex because it's new stuff. Even lawyers.
New to me, but not to you, for sure, right?
No, it actually is, because it seems complex because it's new. Lawyers that come to my continuing ed conferences, they are asking the same questions. They're babes in the wood because it's all regular stuff. We're just stacking it up in a different order, as you had said earlier. Once it's formed, the trust is on the shelf. All you have to remember is, don't call Golden Mountain Lending my company in Wyoming. Call, because you don't want to be in a deposition and have that slip from your tongue.
Right.
We'll still be able to get it protected, but now we have to spend another $30,000 because that door's got open. So you always formally address it. The trust is on the shelf. It's not yours from a lawsuit perspective, and you have the checkbook. You simplify our lives. We theoretically have 2 checkbooks, or a checkbook from a checking account and a savings account. And we keep a little bit of money in the checking account, and we have long-term savings in the others, and we bring money over when we need it. That's what Golden Mountain Lending is. It's your long-term savings account. It has all your liquid wealth and operating capital for the long run. You can take it to consume, or you can borrow it into a real estate LLC to buy another property or put the down on. So your life is just one extra checkbook that, instead of saying, Shannon on it, it says Golden Mountain Lending. And it's really that simple. And if a lawsuit kind of comes on the horizon, then you're going to call Treste Law Firm and say, what do I need to do? Let's make sure all the I's are dotted.
So the reality is that once the complexity of digesting my organization and putting it down on paper and putting each thing in its own protected little box, we set that aside, and all the money flows from the irrevocable trust to an entity that is the holder of the equity, Golden Mountain in the case that we've been talking about today. And from there, distributions come to me. So it really isn't, like I said, it's not complicated. It's just not easy.
It's not easy to get your arms around it, but
or through it, or over it.
Exactly. All those things. But to operate it, it's actually, everybody is astounded. We get that unsolicited all the time.
And that's really where I'm finally coming to the other side of the conversation, where I understand that, okay, once this, because, even with LLCs, I mean, you've got, like you said, you've got meeting minutes for every LLC every year, and you've got, you know, you've got the different credit card for each one, and you can't commingle funds, and you've got to pay this. And so maybe you've got a holding company where, you know, the holding company, you know, pays the bill and then sends a bill out to each LLC, and each LLC writes a check. I mean, that can get very, very complicated and very cumbersome to operate. That's just kind of, you know, you've got 25 properties, so you've got 25 checkbooks, you've got 25 bank balances, you've got all these things. Whereas what you're talking about, once set up, is much, much simpler than that. And it a lot more protection to go with that.
Absolutely.
Now, when the irrevocable trust owns it and I want to sell it, or I don't want to sell it, I couldn't say that in court. The irrevocable trust decides that they want to sell it. I just show up as the agent and sign the papers.
You can do it that way. You're still running the LLC that holds the real property, and you want to run the sale, and through escrow, the profits goes to Golden Mountain Lending, just like Bank of America is going to get paid. And then on your next project, you're going to borrow from Golden Mountain Lending into a new LLC that's starting the new project.
So, Kevin, you know, really what you have outlined here is something that can be done, and probably sooner rather than later, because the complexity of trying to sort out 65 or 75 or 100 different entities and stuff. Whereas if you just call up and say, hey, Kevin, I got another property, it's 124 4th Street. And you say, great, let's call it 124 4th Street LLC. Now we just throw that on the shelf with the rest of it, and we just keep adding and we keep growing. So it's something that, even though, like you said earlier in the podcast, you're only 3 houses, or you're, you know, a duplex and a triplex, that's the great place to start, because then you can just continue to add on to it like Legos, where you're continuing to build it out as you add assets without having to change anything.
Right. And you can even simplify a little bit. We recommend, if the real lawsuit protection comes from the equity stripping, the friendly liens, then you don't need an LLC for every property. If you have an apartment complex, I'd put that in one LLC, but maybe 5, 6 single family residences in one LLC. So you get to simplify a little bit.
So then you're doing a portfolio type package where you're cross collateralizing everything, so that you might have $200,000 equity in each house, but now you're throwing a blanket lien over it for this collateral for $1.2 million. The equity's gone, the payments are coming out to Golden Mountain Lending, and you're able to just consolidate. So now you would have maybe your fix and flip portfolio, your single family portfolio, and your multifamily portfolio. So you could really simplify that. I see where that would work. And so really, by doing the work up front, you could really simplify your life and move forward.
Yes. Yeah. And it's scalable. That one lawsuit proof trust and the one privacy company, the piggy bank company, can equity strip 3 properties or 133 properties.
Yeah. So now I wanted to get through all that so that I can understand it. And that's a lot of groundwork, guys. Feel free to go back and listen to that again, because it's really quite simple once it finally clicks in your head. But now we have, so this is all done.
We have a white paper that explains it.
Okay.
And it will answer 100 more questions. It'll drum up 30 others.
Oh,
we'll be glad to send that.
So what you're saying is, don't read that at 9 o'clock at night, because the sheep will be asking questions all night, right?
Yeah.
So guys, if you want that information, shoot me an email at connect@shannonrobnett.com, and just type in the subject line Kevin Day. We'll get you over that white paper, and that will be a valuable asset. But we just talked about domestically. We've talked about all of these things being in the United States. Now, the problem with all of that, Kevin, is the IRS likes you too when you're domestic. How do you work with people to help them get those assets and those companies and those holding companies and those profits offshore?
Rarely, there's only a few tax advantage. I mean, we have banking connections and we form companies all over the world for various needs. But to be IRS compliant and have a tax advantage structure, there's people with millions and millions of dollars that have followed the law, and when too many people do them, they close. They call them loopholes, but it's the law.
Right.
And one of the biggest thing is having an active business internationally, and very few people are going to be in that position, particularly real estate investors, unless they are willing to get familiar with an international market. Then you'd have what's called a controlled foreign corporation. IRS calls it the CFC. And you report the taxes, but don't have to pay taxes until you're repatriated. And you personally don't have to necessarily leave the country to do that. Then we also have tax and treaty jurisdictions that you're very familiar with, that give U.S. citizens tax advantages.
So when you hear people talking about, offshore trusts and offshore holdings, why would you, if there's very little, what we just described, there's very little tax advantage to that, why would someone want to have their holdings offshore?
Right. Because one, the Hague Convention on Trusts essentially says that we recognize the trust law of these other countries and their jurisdiction over the trust. And it's recognized in all 50 states. It's recognized by the IRS. We're not getting you in trouble. There's actually a form for these things, which you want. It's part of the defense file. But somebody's suing it, trying to bust it, they're going to have to fly to the Isle of Man or Cook Islands or Montserrat, wherever we end up putting this trust. And the rest of the world is not a loser pays. Everybody else is a loser pays system. The US is not. So you sue somebody and you lose, you just walk away, with the attorney fees that you paid. The rest of the world says, if you sue and lose, you have to pay the defendant's fees and costs. Some of these jurisdictions, not all, require the plaintiff to put up a cash bond in the amount of the expected defense fees and costs. And they need to sue under that country's laws. We're so lax here. And so the domestic versions, there's only 15 states that have passed these copycat laws. Only about 5 of them have any teeth in them. So you have issues if you're being sued from somebody in a different state that doesn't have the trust law and you're using the trust law of another state, although it's legal. Those are extra issues. And crazy things happen in our legal system. That's why people have to take it into their own control and get educated on this.
So really what you're doing is you're taking the previously discussed irrevocable trust, putting it in Alcatraz that has Cook Islands, you'd have to physically fly to the Cook Islands, hire a Cook Islands attorney to litigate this process. And then the Cook Islands has a completely different compensation idea that if you don't win, then you not only, it's not in the US, if you don't win, then I have the right and the ability to sue you for my attorney's fees. But then that's a whole nother negotiation. That's a whole nother thing. It's not that you are automatically awarded. In the Cook Islands, you're automatically awarded. I just turned in my bill for the attorney's fees. You lost. Now you pay me, $700,000 for my attorney's fees and all the costs.
Yeah, the courts actually collect that money in advance. They say, we don't want you making a mockery of our system. You lose, you fly back to America. We want you to ante up cash.
Right.
Right.
So what percentage of your clients need that additional layer of protection?
I used to avoid, people would typically ask it, how big does my estate need to be?
Right.
And I would avoid that because unless we're doing something tax advantage, it's really about, protecting what you've worked so hard for.
Right.
And so I avoided it for the first 10 years of my practice, and I've been in 30 plus now. And I finally realized what my clients were selecting. And if they were over $4 million, they tended to go with the offshore trust. And if you're under 2, you go with a domestic. If you're between 2 and 4, then we slow down on the education and look at the pros and cons. How rapidly are you growing? How high a liability business do you have, to see whether it's worth the stretch to go international. I contemplated this. It took me a couple of years to figure it out. And I remember, my dad was a 6th grade school teacher. I've got 25 and 28 employees, now, and have had big firms, and things are nice. But I started with $500 in my bank account, and I started in a Fugent suite. And I remember when you get to about 3 million, you've bought the upgrade car, you're starting to go on nice vacations, and you realize that even if I don't make any more money, I can live a decent life. That's when the light bulb goes on, that it's so critical to pay attention to the lawsuit protection side, not just the wealth growing side. If you're smaller, if you're a business owner, or you've had some little lawsuit, insurance took care of it, it was $15,000, but you realized how much stress and how easy it is, anybody can sue you for anything, then those smaller estates are alert to it, and we want to be there for them.
Yeah. So Kevin, this has been really, really enlightening. And I think I've got, all kinds of thoughts and stuff going through my head about, well, what about this? But, we need to kind of wind this down, because I can go on for a long time about this, which is, I kind of like these rabbit trails. But if you had one piece of advice for my listeners, that, looking at what we think we know versus what we know versus our conversations today, what would be that one piece of advice that you would tell people right out of the gate?
2 things. One, get educated. You might not be putting structure in place. I've got X amount of dollars. I've got something under contract. I can't put a structure in place, but get educated so that when the timing is right, you go, oh, I need to get back to that guy that, Shannon introduced us to. The other thing is we do a roadmap. It's $350. It doesn't cover the amount of time. We put about $800 worth of hours into it, but we customize what your structure is now, what the structure would be perfect for if money was no object, and what are the baby steps to get there. So you're not just willy-nilly adding LLCs and you're throwing things away that down the road it's not as streamlined. So the roadmap is an efficient way to imagine the future that you want and slowly build toward it.
Yeah. Well, and that's exactly why I started on this journey with this podcast, is not because I didn't have anything to do with my afternoon. It was because the educational piece that, being able to speak with guests like yourself and Dave Zook and some of these others that are really high power people that really know what they're doing, that really have their niche and their specialty under control, to give that education. So I really love the fact that education is really what you're leading with. But I'm going to add to that, guys. I'm going to tell you that lawsuits are not cheap. Okay. I've been involved in a couple, not my fault. But even when it wasn't my fault, it was somebody else's fault. It still cost me a lot of money to defend myself, because at that particular time, I did not have what Kevin has been talking about. So you really want to take the time to invest in your education, and you want to invest in asset protection before the lawsuit happens. Because if you think for 1 minute that asset protection structure is expensive, you clearly have not been involved in a lawsuit. Those, my friend, are expensive, and nobody wants those. But Kevin, I really want to say thank you for being with us today, because you brought an angle. You brought, and obviously your life's work has been about this, but you brought something to my listeners that you don't hear all the time that is going to give everybody pause. And I really want to go back to the white paper that you offered. Guys, connect at shannonrobnett.com. We'll get you a copy of that white paper. We'll get you connected with Kevin Day. And I completely agree with what Kevin said, that you need to start now and you need to get that roadmap so that you're not adding on the wrong things or doing the wrong things. But Kevin, I can't say thank you enough for spending your afternoon talking with us. I really appreciate the knowledge you've given us.
I always have so much fun with you, and thank you very much. And I know it's not the most heartening subject. It's so much more fun to learn the things to make more money, but spending a little bit of time on how to keep it is important.
Well, and that's always, again, that's that preventative maintenance, right? You don't know that you're really making money when you're working with your asset protection attorney, because you're protecting yourself from that. And when your mind is occupied with a lawsuit, you're not in your regular space and you're not doing what you could, right?
Yeah.
So guys, thanks for tuning in to the Real Estate Rundown. Don't forget to like, share, and subscribe to the Real Estate Rundown wherever you get your podcast. Leave us a review. I'd love to hear your feedback. And if you want that information, that white paper, don't forget, connect at shannonrobnett.com. Other than that, you guys have an amazing day.
That's a wrap for today's episode of the Real Estate Rundown. Let these newfound strategies pave the way to start a successful career or a profound rebranding. If you loved everything you have heard, listen to more conversations at www.shannonrobnett.com. And be sure to leave a rating, share it with your friends, and subscribe. Until the next episode.